So it is a
You're right. To that extent, probably the intent was that you amend the domestic laws
also in tune with this.
so that the challenge is also on limited number
Limited.
of grounds and same grounds which are available when you challenge the New York Convention of Law.
Exactly. I'm grateful.
But
then next,
have we restricted ourselves to that?
We have. I can't say about fortunately or unfortunately, but in 96, we were not under any obligation not to deviate.
After 96.
Lord, it's evolving. I can say, my Lord, it's evolving, but ultimately, my Lord, some way will have to be found. But at the end of my submissions, my Lord, the way can be somewhere else, not
So
here.
the idea was that national and international should be the same grounds. So it becomes the enforcement of the awards becomes
easier. And my Lord, also incentivizing other jurisdiction parties to come here and arbitrate on the ground that arbitrate award would be final. There would be very limited challenge to it. So your dispute resolution would be faster. Suppose we have 15 grounds or we have 20 grounds, then it might disincentivize others to come. That may be, my Lord, perhaps the intention. Please come, my Lord, now to para 2. The application for setting aside constitutes the exclusive recourse to a court against the award in the sense that it is the only means for actively attacking the award, that is, initiating proceedings for judicial review. A party retains, of course, the right to defend himself against the award by requesting refusal of recognition of enforcement in proceedings initiated by the other party. Obviously, Article 34(1) does not exclude the right of a party to request any correction or interpretation of the award or making of an additional award under Article 33, our limited, but our Section 33, clerical and mathematical errors, since such request would be directed to the arbitral tribunal and not to a court.
Give me the arbitration.
Continue. No, Your Lordship may see it. I would like Your Lordships to be with me in reading this.
The teaching, in fact, goes beyond that. Beyond that, it goes also.
I'm saying
Clause B goes beyond that.
Yes.
It says, if so agreed by the parties, a party which is a notice to the other party may
request the arbitral tribunal to correct any computation errors, any clerical or typographical errors, or any other errors of a similar nature.
And B, if so agreed.
This is Article 33.
That's why, that's clause B now.
Page 929, my Lord.
That's B of Section 33. Asking the arbitrator
if so agreed by a
interpret
party with notice to the other party may request the tribunal to give an interpretation of a specific point. My Lord, 929, the ancestral Article 33 also has that.
Same is there.
Same, 929, my Lords. To give an interpretation of a specific point or part of the award.
The notice is earlier. They would activate entity.
We have, my Lord, done an excellent work of copy pasting, my Lord, at that time, my Lord. Then, my Lord, kindly come to 934. Again, my Lord, we are not on remission. My Lords are examining modification, but still I may show what they felt. Paragraph 4, which becomes our section 34(4). Envisage a procedure which is similar to the remission known in most common law jurisdiction, though in various forms. Although the procedure is not known in all legal systems, it should prove useful is that it enables the arbitral tribunal to cure a certain defect and thereby save the award from being set aside by the court. So defect, that was the intention. Unlike in some common law jurisdictions, the procedure is not conceived as a separate remedy, but placed in the framework of setting aside proceedings. We have done this, my Lord. It's a part of 34, our 34. The court, where appropriate and so requested by a party, would invite the arbitral tribunal whose continuing mandate is thereby confirmed to take appropriate measures for eliminating a certain, please mark, remediable defect which constitutes a ground for setting aside under paragraph 2. So first it has to be remediable defect, and it should be severable. But, my lord, there are judgments where, despite the power of remand or remission having been exercised, the tribunal says that no, we uphold our decision. Matter goes back to my lord, the court which we call 34 court. And court said, now we have no other remedy, we set it aside. That's how, my lord, internationally, unless in some countries where they have deviated while making their domestic law to be non-compliant to Article 34. There are countries, as I have said, my lord, United Kingdom, United States, Canada, France. France is, of course, not a signatory to UNCITRAL, but they have a separate mechanism providing for what they call variation in the award. The court has a power to vary the award or modify the award. But otherwise, everywhere, my lord, setting aside means either you set aside or you affirm. Unless you can sever it, then set aside only in part. Now, my lord, please come to, I am coming to an end of this, my lord, page 945. 941, my lord, first. We have India has participated in this debate, my lord. 941. Para 8. Lord, Article 5, Lord, kindly give me, my lord, a little, allow me to have a preface. Article 5 is our section 5, which says that no recourse against an award except as provided in this act. My lord, section 5, it's a two-line section. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, that is part 1, domestic arbitration, no judicial authority shall intervene except where so provided in this part. Now, that is Article 5 of UNCITRAL also. Now, my lord, in this context, please read para 8. The United Kingdom had dwelt on the difficulties which might arise in deciding how to read Article 5 in a situation concerning which nothing was found in the model law. There might, of course, be nothing in the model law about a specific situation, but in that case, it would be necessary to look at the provisions of the model law dealing with the area out of which the situation had arisen. He agreed that decisions on individual cases would be very difficult to make, but he doubted whether the model law could go beyond using the word in matters governed by this law. He in fact said that don't make it wide, give us a choice. The choice was not restricted or given, but the Britain has used that choice. I'll show, my lord, the corresponding provision in Britain. United Kingdom's written comments included the question whether it was really the intention of the model law that Article 5 should operate to exclude judicial control in situations not foreseen by the working group on international contract practices. That was obviously not in its intention, because the list of matters which the working group had decided not to deal with in the model law was clearly given by way of an example only. Now, please come to the next page, para 11. Mr. Sekhon, he represented India in this UNCITRAL working group. Mr. Sekhon, India, said that his delegation endorsed the United Kingdom's objection to Article 5, but would not like to see it deleted. It was important that model law should find wide acceptance in different countries. In India, for example, judicial control of arbitration was sometimes exercised by the Supreme Court. In the states, the high courts under Article 227 exercised superintendence and control over various tribunals, including arbitral tribunals. Those controls should not be removed. His delegation could accept Article 5 if it was modified to enable parties to opt out of it. But I must tell your lordships at this stage, there is a constitution bench judgment on this point of our court, which takes the view that Article 227 is not permissible. But thereafter, there is a two-judge bench in Deep Industries, my lord, penned by my lord Justice Nariman, my lord, who has taken the view that for some cases 227 can still be invoked against an arbitral tribunal award, my lord. But we are not concerned with this. This is what was discussed, my lord, in the. Now, your lordships may kindly come to page 945. Lord, these are various meetings. I'm not giving the name of the meeting, my lord, but 945. The date of the meeting. My lord, date of the meeting is in my note. My lord, I have given the date of the meeting, what happened, and I'm just taking your lordship through the relevant paragraphs.
We have only reached 1985, 11 more years to go.
No, yes, but my lord, there are only 4 pages to go. Lord, those who forget the history are condemned to repeat it. Lord, I don't want to forget the history because my 34 is based on this discussion. That's the problem. And your lordships must know, my lord, what was intended. Now, my lord, para 4. But, my lord, underlying message taken. Underlying message of my lord Justice Sanjay Kumar, my lord, taken. Yes. Para 4. Sir Michael Mustil, United Kingdom, expressed concerns that the exclusive list of grounds for setting aside an award would not cover all cases of procedural injustice. In its written comments reproduced at so-and-so, his government had given some examples of that. The concept of public policy mentioned in para 5, para 2b2 did not exist in his country, and he could not say whether in other countries it would cover the examples he had mentioned. His delegation would welcome the addition to the article of a more general formula to ensure the possibility of recourse in all cases of serious procedural injustice. Now, 7 is India's 10. Mr. Sekhon agreed with the United Kingdom representative that the grounds given in Article 34(2) did not cover all possible cases. The Commission might, for instance, wish to include a provision covering misconduct of the arbitrator. If so, he would suggest suitable wording from his country's Arbitration Act. 1948 was the act in force. The question of public policy was a delicate one. It might, for example, be the public policy of a state with a considerable foreign debt to prohibit payments from being made to creditors in foreign countries, including payments owed under international commercial arbitration awards, etc. But, my lord, this was just a suggestion and nothing, my lord, happened thereafter. Please come to 949. First, my lord, 948, my lord. It would be necessary, my lord, Hungary, because we accepted what Hungary said. India agreed to that. But 948, your lordships can skip, my lord, nothing may perhaps turn. But 949, right side column, Mr. Sekhon, para 34. Your lordship gets, my lord. Para 34, 2b, para 34, where they discuss Article 34, 2b, Roman 2. Mr. Sekhon stated that his delegation would prefer to see paragraph B2 deleted. Now, B2 was public policy. Your lordships can mark page 930 is that B2, my lord. Page 930. The expression public policy was much too vague and had very little to do with the law of arbitration. My lord, this was really correct. Public arbitration is a contractual dispute, my lord. There may be minimum existence of a public policy, except, my lord, in some rare cases. If the subparagraph was retained, the Commission should consider deleting the phrase or any decision contained therein, which was superfluous, as whole necessarily included all of its part, and the decision was part of an award. Now, your lordships may come to 953. Now, my lord, I am quickly coming at the end. 953, para 5. Mr. Sekhon said, your lordship gets, my lord. that his delegation was in favor of paragraph 4, which is our 34(4), which is power of remission. The fact that such a provision was not found in some legal systems was not a reason for excluding it if it was meritorious. The aim, after all, was to harmonization of law. It was not, it was domestic law harmonizing at the global level. It's very clear throughout. He suggested that the words "an opportunity to resume the arbitral proceedings" should be replaced by the word "an opportunity to reconsider the arbitral proceedings." Not accepted either by UNCITRAL or by our parliament. We continued with resume. Now kindly come to page 958. At 1016. This is the final.
Zero 016.
Lord, this is where Article 34, as it became a model law, took the final shape. There is no change thereafter, my lord. Lord, they have also gone into corruption, etc., my lord, which may be, but that is ground of public policy, my lord, they have said. But right now, my lord, though it is a very serious ground and a serious concern of everyone involved, but may not be relevant, my lord, for the answering the present question. 1016, my lord, your lordship gets, my lord. Recourse to a court against an arbitral award may, in the territory of this state, under this law, may be made only by an application for setting aside in accordance with para 2 and 3. So, my lord, linguistically, purposive interpretation, whichever means of interpretation we may employ, as the law stands, which we have adopted, is the power to set aside. Set aside can be either whole or in part, if there is separable. But power to set aside. And I'll show, my lord, the countries which have not accepted this model, they have provided for the power of modification and variation. Now, your lordships may, my lord, kindly see 1022. Paragraph 4. So this is again remittance. But remittance, we are really not concerned. Power of remit.
What is the point of having power of remittance? Then they can also do it.
Lord, one more aspect, my lord, can you bear this in mind?
Yes.
But if we read power of modification or power of varying the award in section 34, then, my lord, subsection 4 becomes meaningless. Why remit it? If you find there is something wrong, modify it. But because it only permits setting aside, there is a provision that rather than setting aside, to save it being set aside, let us give an opportunity to rectify curable defects. Lord, the very fact to the arbitral tribunal, the very fact that there exists subsection 4, which provides for remitting, which, my lord, says that rather than setting aside, we would rather give an opportunity to the tribunal to correct if some of the defects can be cured. My lord, the very existence of 4 would nullify, my lord, any reading of modification power or varying power in 34. My lord, now, my lord, come back to the note. My lord, this is over, my lord. We accepted.
While the first part of your argument can be appreciated, that setting aside in the context, the way UNCITRAL proceedings had gone about and with the idea to have uniformity. To say that only on the basis of subsection 4, power to vary cannot be exercised may be slightly difficult
Not only,
because that's a separate power.
it's a separate argument that
That's
the
a
very
separate-
existence of court,
Mainly because you have one recourse or remedy available.
you may choose another lesser. But I can understand, but if your lordship,
You may have two or multiple concurrent remedies available in a given case. Mainly because implied bar can argue based upon the power of setting aside, which doesn't use the word vary or modify, along with 34(4), you can argue together, let's say implied bar, therefore for the court to modify or vary the award.
well, I bow down, Mallu. There is no difficulty about it.
But
As the
only
way
on four you can't rely.
Lord, I wish your lordship finds a power of modification in 34, but it appears to be very difficult to find one. For the reason that subsection 5 says that except provided under the Act, there is no remedy. What is provided is 34, which is power of setting aside. And 4 provides that because we can only set aside, rather we remit. And that's how, my lord, that subsection 4, wherever it existed, is understood by all jurisdictions. That since the harshest and the only remedy is to set aside, 4 is a lesser remedy. What possibly, my lord, the Chief Justice says is that there may be a power of modification, but the court in a given set of facts may feel that rather than my exercising the power of modification and varying the award, I may send it back on a particular issue if there is a curable defect. But, my lord, what happens? I'll take your lordship to 34. My lord, they kindly have 34. You'll have to, my lord, set aside, but there is no power of modification, my lord, thereafter. 34. And then, my lord, I'll come to the position in England. They have a specific power of variation. But England, USA, etc., they were in the lead while forming this model law, but they eventually did not follow model law. The rest of the country, rest of the world, my lord, followed model law. Most of the countries have followed model law. Lord, kindly see 34. An application for setting aside arbitral award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. So the only prayer one can make is that set it aside. There is no other prayer permissible. Either we go by the literal interpretation or any other interpretation. Now please see 2. An arbitral award may be set aside. Again, my lord, set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that ABCD I'll come to little later, but unless the party requesting for setting aside satisfies, there is a finality attached under our scheme to the award. Now, my lord, kindly for the time being skip to the grounds on which it can be set aside. Lord, come to 3. Lord, 3 is limitation, come to 4. Limitation, we are not concerned. 4. On receipt of an application under subsection 1, that is requesting that you please set aside on these grounds, the court may, where it is appropriate, and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume arbitral proceedings or to take such other action as, in the opinion of the arbitral tribunal, please mark, will eliminate the grounds for setting aside the arbitral award. So if they do not do that, the only consequence would be setting aside. Now, having seen this, please read grounds of setting aside. 2, subsection 2.
The language used is very careful, very carefully selected. Eliminate the grounds. It
Yes.
doesn't talk about grounds to set aside the vote. It says eliminate the grounds.
Eliminate the ground. Can you?
So final adjudication at that stage may not be required. That the grounds for setting aside of the arbitral award have merit. Says eliminate the ground, because eliminate the ground.
Otherwise, we'll have to set aside. You eliminate it.
No,
Otherwise, the
no,
grounds
there
are
are two ways
such that we'll have to set aside.
There are two ways to interpret it. Eliminate the grounds for setting aside of the award. Eliminate the grounds means to eliminate the grounds which are raised by the party raising objections. One, maybe examining them prima facie. Two is the second stage where you don't examine it prima facie. You come to the conclusion, yes, these grounds have actually substantial merit and the award is liable to be set aside. But I will not set it aside. I'll give an opportunity to the tribunal to rectify.
Because I can only otherwise set aside.
No, there are two ways to do it. One is what is the level of the opinion formed by the court? The question is, what is the level of the opinion formed by the court under subsection 4 when it will exercise its jurisdiction?
It can't be prima facie. It can't be prima facie.
According to you, it will be when the court forms a firm conclusion.
Yes, my lord. And if we read, my lord, the way, my lord, it is suggested, then why not set aside?
So now, if we do that, if we accept that argument, it will mean virtually your court has to then record reasons why it's setting aside the award and then saying I'm making an order or remit.
It will have to. Okay, it will have to. It can't be remand simpliciter. There are some.
Upon the request of a party.
And it
Section
says
4 says it is upon the request of the party that the court will remit it,
Yes,
not automatically. The request must also come from the party.
correct, my lord, correct. My lord, request means,
Solicitor, yes,
my lord,
keep this solicitor.
my lord,
Solicitor General.
my lord,
Who will normally make the request?
the aggrieved party,
Party who.
losing party.
Party who has succeeded. Because he will say predominantly, for heaven's sake,
Lordships are right. That otherwise my,
set aside the award, some document not supplied, just get that without upsetting the reasoning, just get that sorted out. Because the party who has filed the application wants a complete setting aside of the award.
correct. It would be used by the respondent.
Respondent invariably, unless the party is clear to the party that, look, the award is not going to be set aside in full. Let me at least salvage.
In some cases, yes.
So invariably by the respondent. Now, suppose in matters of interest, etc., unless the court expresses a view.
Severable. It can be, my lord, the interest can be immediately.
To what extent? Substitution is also severance. Can 16% be made 12?
You are partly setting it aside.
You don't have to resort to 34.
My lord, please have a look at 4 again, my lord. Can I read 4 again?
Yeah.
Please read it with me, my lord. 4. On receipt of an application under subsection 1.
subsection 1 application is by the party
By the
which is
party who is losing.
objecting to the award.
Award. So, and subsection 1 provides that request for setting aside. So, only remedy and the only prayer before the court would be to set aside. The court may, where it is appropriate. So, as I have said, my lord, appropriate would mean that court may say that sending it before the same tribunal may perhaps not be appropriate. I may rather examine it. And it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the tribunal will eliminate the grounds for setting aside the award. So it will have to
will eliminate, will mean the ground which is raised but not final, which ground which is raised by a party but without forming a firm conclusion or only after forming a firm conclusion that.
Would your lordship, would your lordships now come to subsection 2? Because these are the grounds which are to be eliminated.
Is
What
there
will
any, is there any direct decision of this court on that? No.
No.
34-4, on the
The
conclusion.
Dyna, which is,
No, that-
I pay doesn't follow.
There is,
I pay, my lord, Justice Reddy's judgment.
Judge.
Where Dyna is considered, my lord, not followed, but considered. I'm coming to that, my lord, that is a part of my submission. My lord, kindly see, my lord, now the grounds which are the defects which can be cured under 4. 1, A1, 2A1. The party was under some incapacity. Lord, meaning thereby suppose the one of the party was a minor. So there is no question of sending it back because this is not a curable defect. Arbitration between, my lord, am I with your lordships? Arbitration agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law for the time being in force. Again, my lord, it can be remitted because the court will have to at least prima facie form an opinion that arbitration agreement is not valid arbitration.
arbitrator cannot make the arbitration agreement valid, so it cannot be done.
Correct. So, my lord, this is not a defect which is, I would say,
Curable.
curable under 4. Then 3, the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. But for 4, the only remedy was to set aside. Therefore, 4 says,
No. Three, last part is very important. Or was otherwise unable to present.
present his case.
This will be the most resorted to.
Correct.
You'll
Your
find a
lordship,
similar
correct.
phrase in part 2 also.
Correct. So,
Natural justice part.
my lord, I as a respondent give some document behind the back of the petition,
Yes.
or some argument made behind my back, and I was not given an opportunity to meet with that. So that this is curable. But why? Because otherwise, but for this curing, I will have to set it aside. So better I remit it. That's, my lord. In my reading, my lord, I wish your lordship finds out a way. I wish a judicial supervision on arbitral proceedings, because complete needle of the eye test has created more problems than, my lord, what was intended by restricting the challenges. And all of us will agree on that, my lord, on all sides, my lord, because we have suffered, my lord, awards several times. The arbitral, then 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration.
Well, 4 apply in this Roman 4 also, situations covered by Roman 4, subsection 4.
Their severability is provided. But court will have to prima
Now, suppose it's not possible for a court to sever it because of the way the award
then
is.
set aside.
Can you resort to subsection 4 to deal with the infirmity created
Cannot.
by 4?
Cannot be. For 2 reasons it cannot be. My lord, one, if it is not severable, there is no question, my lord, because proviso, kindly read the proviso. Provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decision on matters not submitted may be.
No. This doesn't deal with the power of the tribunal. This deals with the power of the court.
Correct, my lord.
This does not deal with the power of.
No.
No, 1 minute. This deals with the power of the court to set aside the award or partially set aside the award. But it doesn't curtail the power of the court or contain the powers of the court under subsection 4. Say, in a given case, arbitral award combines 2 claims together and passes an award clubbing them and says both the claims are overlapping. And that they can be various situations. We can't visualize all situations.
Cannot be.
But the court then feels this part of the award, this part is not covered by the arbitration clause. And wrongly it was held by the tribunal, it's covered by the arbitration clause. Because validity or existence of the disputes covered by the arbitration clause is a complete
X.
review. It's a complete review. It's a pure review by the court. It's not a,
Permissible.
it's a permissible complete review.
The impermissible review.
No, whether a dispute is covered by the arbitration clause is a complete review
Yes.
by the court under the. It's not restricted by any other.
34(2) or other
Yes.
restrictive provision.
It's a complete existence of the arbitration clause. Its second look is complete. Unlike when so many times when lawyers come and argue, they say it's not going to be complete. I've seen even over here, sitting with my brother once or twice, it's a complete review. It's not a half review, or whether the dispute is covered by the arbitration clause is a complete review. But if therefore, when you set aside you feel I have to set aside the award on that, can you not pass an order or remit under subsection 4, segregate that part?
You can remit, but there is no difficulty about it. My emphasis is not that there is no power of remitting. My emphasis is the power of remitting exists because there is no other power other than setting aside. So you save it if you can save it, because rather than setting it aside, resort to a lesser, if I may say, my lord, the procedure, so that it is saved. Otherwise, I'll have to, as a court, I'll have to set it aside. Then, my lord, C4, 5.
Just 1 minute, just 1 minute.
Yes. But please come to 5. 2, 5. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless such agreement was in conflict with the provisions of this part from which the parties cannot derogate, or failing such agreement was not in accordance with this part. But if suppose the court comes to this conclusion, then there is no question of remitting, because the very foundation goes. The composition of the tribunal itself is in question. Then the remedy would be setting it aside. Then D, the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law. But again, remitting will not help. If this is a conclusion, then award will have to be set aside. I wish your lordship finds, my lord, some power of modification, but the moment, my lord, I will show other jurisdictions which have not followed 34 to the hilt, and they have tailor-made their, my lord, statutory provisions based upon their domestic situations. They have specifically provided for the power. That's the problem. I am not arguing that it has to be set aside. The law as it stands only empowers setting aside.
Listening, it also addresses on the scope of the phrase, set aside, modify, because reversal is not modification. A claim can't be, a rejected claim can't be awarded. That will be reversal. It's one of the claims in Gayatri Baluswamy, there was a setting aside and a reversal. That can't be done. But set aside, is it not a word of wide import?
Wide magnitude.
Modify also. Our commonly understood notions of modification we keep aside. And you look at some words and phrases, modify without altering the basic structure. Suppose of the awards. Suppose there is a setting aside in the broad sense, interest chopped off from 16 to 12 in the interest of justice.
But the word setting, that phrase setting aside, is used in a particular context in the model law, which also means annulment and vacatur. Setting aside has a particular.
Is it only that? Is it the binary of setting?
That's the
the
only interpretation.
My lord, that word, that
Intent.
phrase, that phrase setting aside, my lord, has a particular meaning. We'll show, my lord, what is that meaning of that phrase. One
Then
argument.
you are adding the word wholly set aside.
My lord,
Set aside.
it also, my lord, set aside in whole or in part is also a part of annulment. You can always set aside a part, but whether in
The setting aside of a part is only confined to a particular circumstance covered by 3, covered by 4. It is not possible.
Severability. and
Severability is only covered by 4.
If contingency.
Correct.
Four.
But in a given situation, just like normally, where do we get into difficulty? Let me put it very clearly, where do we get into difficulty? One case is obviously the interest part. So its irony is now gradually we are coming down to mandatory rate of interest.
Mandatory.
Rate of interest being
Yes.
specified. We gradually come into the, if we go by MSME Act, it's 36%.
No, this is against public policy. No, we can virtually argue. Someone can argue.
Anyway, but we are gradually going to mandatory rate of interest. But there's another circumstance which we always face. We find that the arbitrator has awarded, say, damages, but it twice over. That's normally a problem.
But one thing
Then,
on,
then
That's a major problem. If what happens is you award it, say, for ideal labor, and at the same time you award it for the bank interest.
correct. But my answer is this.
Then
If it-
it becomes, you want to, then at that time, it's not covered by the arbitration clause. It's not an issue which is non-arbitrable.
May I answer?
Clearly, you feel there's overlapping. There's a clearly overlapping which is taking place.
The answer is this.
That's
Only a minute.
normally
Mr.
the
Dav-
situation.
Answer. Let me answer.
okay, fine.
Let me answer.
I wanted to show Article 36 of UNCITRAL must be seen. The grounds to set aside the award are identical with the grounds not to enforce the award. And there is a commentary in United Nations why the ground to set aside the award. Because what happens in 34, the award is international commercial. One of the country's participant can set it aside in his native country.
That
Those are the
was
grounds.
Right.
Otherwise,
The UNCITRAL-
enforcement.
The UNCITRAL framed it. They were catering to all countries.
Exactly. And what they say is,
What could be part 1 in one country could be part 2 in another.
Yes.
They had to formulate something uniform.
No, therefore,
I'm
we will
on a-
not
I'm
get
on a-
any
I'm on a
assistance
slightly
from
different point.
articles or commentaries.
no, I'm on a
That's the
different point.
difficulty.
1 minute. I'm on a
Because
different
every
point.
author has written commentary based on his domestic.
No, one minute,
situation.
1 minute. In the commentary, they say, how come you have kept the same terms and conditions for refusing to enforce the award vis-a-vis setting aside the award? So they say the grounds for setting aside are the same because if the award is set aside, like annulled, it also can't be enforced. So even if I don't challenge it,
Correct.
I come for enforcement. There also I can. So that's very important.
So
And
the
the commentary
award
not-
must be, if it is set aside in the country where the law of arbitration is applicable to that situation,
The agree party.
then obviously it cannot be enforced.
No.
There are laws.
This is a very important point because for annulment,
Some
Lord, I'll
cases
just
where
answer that question, my lord.
award set aside in France, enforced in England.
yes,
Award set aside in
Russia, UCOS,
America, etc.
UCOS award.
Your Lordship is thinking of the Putra Bali case.
Bali or
At its seat set aside, but impossible.
See, the whole difficulty is that That's why when just Mr. Chandrasekhar Rao in his book, he says, we wanted to adopt 34 after making proper modifications.
Books, my lord, I
No
don't think can
modification was
assist
made.
or lead us
The
anywhere.
tragedy was no modification was made to 34. Everything was copy pasted.
And
That was the problem.
awards upheld.
But
not
then the
enforced.
solution is the
Awards
same
upheld.
place where the mistake occurred. That's
No.
the argument.
No, that is called delocalization, where the award is upheld in Russia, but another country can refuse. That Sundaresh Menon's lecture is there as to when delocalization can be done.
We rely on lectures and articles.
Dallas case.
Dallas case.
That is.
But that's not different. My only point was 34 was adopted verbatim. Intention was to make proper modification. It was not done. So it's really a square peg in a round
That's
hole.
exactly that
which
it
we are
needs to be
suffering
done
now.
legislatively. That's what you can't read it. But the answer to my lord's very pertinent concern that suppose there is a double damage is awarded. But the answer is simple. If it is severable, that part will have to be and can be. Only a minute.
Under which section? In which part will?
Four
Four, see,
Four.
look at four.
deals with a dispute not or public policy or patent illegal.
No, but for public policy, the proviso doesn't apply.
The patent
Until unless we read, setting aside will include partial setting aside.
my lord, question answer
And
is
that partial public.
my lord, let me put it, my lord, as clearly as possible. The example given by your lordships may be a good justification for power of modification.
But then say it cannot be modified.
Cannot be modified. It has to be set aside.
It has to be said. Then argue, don't say partially.
Yes. Well, justification does not confer jurisdiction. There may be cases where there is a justification. And I, my lord, agree. But all of us agree. There is a need. We are only arguing, can we find? I'm sorry, my lord, I missed something interesting, my lord, which we are supposed to miss. But all of us agree that there needs to be a judicial supervision, intervention, whichever form, my lord, over and above, my lord, 34, which would be in furtherance of and in the interest of the arbitration in general. We are just, my lord, examining and assisting your lordships whether the law as it stands permits that. Without reading into it, supplementing words, legislature can do it. As a matter of fact, one committee, my lord, where the only domain expert was my learned friend, recommended modification.
Okay, now let me come back to subsection.
Only what the learned Chief Justice said can come under basic notions of justice. Because nobody would, no justice would warrant a double award.
Correct.
So let's give a
Then remedy.
so let's say a given case where the arbitrator
Partly set aside, yes.
where the arbitrator has taken a particular clause as liquidated damages.
73, 74.
Because these are normal, they take it as liquidated damages, 20,000 or 50,000 rupees a day. The odds you feel when you read the award, you come to the conclusion, yes, there's a breach. Damages have to be awarded, but this is penalty, not liquidated damage. Can you take resort to 4?
It would perhaps be patent illegal. That's how the patent
Can you
illegal.
take resort to 4? Subsection 4.
But as of now, no. DINA doesn't say so. Doesn't permit that. But IPAD has diluted DILA, my lord. And I think, my lord, my respectful view is that the next judgment is, my lord, a little more sound on this principle. IPAC. I'll, my lord, cite few paragraphs from DINA and IPAC both. My lord. This is dealt with. Jurisdiction. My friend is right. Lord, your lordships have given one or three examples, but there can be many examples.
So I'm just giving examples which normally
Yes, yes,
occur
where
when we
modification is
confronted
needed.
with that situation, whether
nobody's-
instead of setting aside the award, sometimes feel, okay, we know this is the damages, this is a penalty clause,
Lord,
let it
visualize
be into it.
visualize a situation. Your lordships, in a 5-judge combination decides and empowers section 4, that is 34 court, subsection 4.
Why will you do it?
All section 34 courts in India, Lord, where 34.
But that's equally as far as interest is concerned. Again, interest, when we reduce the rate of interest or enhance the rate of interest.
Unless before your lordships under 142, that is what is done in past,
No, 142 is something different.
but not by the district court or the high court. My answer in law is clear. Not that that is a good thing to do. There needs, my lord, a change. The question is whether the law as it stands permit. Lord, otherwise, my lord, the 34 proceedings go before district courts, high courts, and eventually before your lordship. But the first court of first instance, would be district court and high courts. Lord, it might be counterproductive, my lord, to split subsection 4 and read something into it so as to permit, my lord, either modification or remitting beyond the scope which is intended.
No, we are not going by that. We go by the term, we give an expansive meaning to the term, setting aside, to subsume in it a lower.
Lord,
That
that is a part of my written submission. But it does the larger involves the smaller, includes the smaller, but larger includes the smaller of the same genre.
If we can knock off and annul the award, why not partially annul it?
Your lordships can. But your lordships for modification,
That power of the Chief Justice said should inhere, because what it does is effectuates the final power.
my lord,
And such
there are
things-
two answers. There are two answers. Lord, setting aside in part may include, I'm sorry. Setting aside may include and will include setting aside in part. That is annulment in part, not modification,
Rewriting. Modification practically amounts to rewriting.
rewriting.
That power will you say is part of the whole.
Number two, for modifying the 34 court will have to go into the merit review, which is purposefully prohibited.
May not be fully.
It will have to.
Not in all cases.
Not in all cases, but my lord, what about in some cases? But my lord, I don't think, my lord, jurisprudentially, setting aside can include modifying. Setting aside may include setting aside in part.
But when you modify, aren't you setting aside that part? To the extent you modify?
I don't think, my lord, that would be doing violence to the linguistic meaning of the word. And my lord, there are judgments on this.
Why restrict the power of the court?
No, the act, the way it designs and the purpose it seeks to achieve, the purpose is to restrict the power of the court. Minimalistic interference. But it's not, my lord, a good thing to, I'm not, my lord, justifying.
Look, there's one way, that's one way to look at it. The other way to look at it is, it's the objective of every law that the litigation must come to an end.
This will ensure, my lord, it flares up. Kindly see, my lord, the district court, my lord, in some, my lord, most of the states, my lord, irrespective of the pecuniary jurisdiction, 34 goes before a district court or a commercial court. And my lord, it's a wide open field.
They are equally good. They are very good.
No, I'm not saying the competence level, etc. I'm saying, my lord, the enormity of the problem which will arise throughout the country, where everyone would have its own thinking process, justification, logic, whether I should set aside, I should modify, I should remit, I should vary, I should do it in part. Therefore, my lord, the law is clear. You can set aside or you can remit on the limited grounds mentioned in 4. That's our interpretation. And of course, correction under 33. Because otherwise, if the modification is read in 34, even at appellate stage, it can be modified.
Yes,
So there has to be. But I'm not saying no. Appeal is a continuation of the original proceedings. If the power is there in the court of first instance, it would continue with the higher appellate court at least. But can I? It's one of. Can I start the at 2 o'clock?
First.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।